We're live now, Dawn, so watch what we're talking about. Um, I want to thank everybody for being here. Ray Dickey from South Carolina CAI and Hudson Valley CAI and Association Help Now. We're in a bunch of different states, and if you're here, you probably already know what state we're in and where you're from and all that kind of good stuff. Before we go, and I have my panel introduce themselves, I am going to launch a poll, and I'm still trying to get used to this new system. So, if you are here for CEUs, please choose accordingly. If I close the poll before you have time to fill it out, everyone has a question feature. We also use it for comments. I love questions and I love comments. I hate sitting here when I don't get any, and they actually help the program a lot. So please send me questions and send me comments. I don't use people's names, so feel free to ask whatever you would like to ask. I could make a mistake, so maybe don't send me anything too top secret, but I haven't made one yet. So I'm going to close this poll pretty quick. So if I closed it before you had time to fill it out, just use the question feature and say, hey, Ray, I need CEUs. I'll figure out. If you need them for Florida, just mention you need them for Florida because it's a different process. But whatever, I'll figure it out. Back to Florida. You are going to get a link for a survey. You need to fill that out. It's part of the state licensing requirement. So for CAM ICB, you don't need to do anything else. But for Florida, you need to do that. So make sure you pay attention to your email and you do that and you take care of it. Next week is Memorial Day. So there's nothing going on. So we're going to take kind of like the week off, and I'm actually going to do a lot of changes back here. I'm hoping to kind of upgrade a little bit. Okay, so let's have our panel introduce themselves with who I see first, and that is John.
Good morning, John Legumina from the Legumina Law Firm in Purchase, New York. We represent condominiums, co-ops, and homeowner associations from New York City throughout the Hudson Valley areas.
Sean.
Good morning. My name is Sean O'Connor. I'm an attorney. I'm a shareholder with the law firm of Clarkson, McAlonis, and O'Connor. Our office is in Mount Pleasant, South Carolina. We have a statewide community association law practice offering full service representation, and we have clients in all regions and markets of South Carolina. I'm very active in our South Carolina CAI chapter. I've been a member of the chapter since 2008, served on the board of directors for a number of years, was president of the chapter in 2023, and also serve on the Blue Ribbon panel, and I'm a member of the CAI National Business Partners Council.
Sean does a tremendous amount, not only for the chapter, but for people, just for people in general. They don't even have to be members. He tries his best to help people out. Greg.
Good morning, everyone. Greg Girelli with Girelli Insurance Agency. We're located in Cold Spring, New York, and we have insurance master policy programs for community associations throughout the Hudson Valley and surrounding New York, New Jersey, Connecticut, Pennsylvania area.
Corey.
Good morning, Corey Kravitz. I'm the managing partner of KSN's Florida office. We represent community associations all throughout Florida, Illinois, and Indiana and Wisconsin. Appreciate being here today. Thank you.
At the last live stream, Corey, before we went off, kind of ended, I had said, who would I stay with if the world came to an end? And I actually did get a lot of questions about, because I couldn't give my answer. There wasn't any time. And I'll just do it really quick. The reason I picked Corey was, first, John has like adult children in and out visiting him all the time. I don't want to be at that house. That's crazy. Sean, his lifestyle is too insane for me. He's too busy. He's just very, very busy person. I don't know if Greg was there or Deb was there. They're just too nice to Girellis. I just know it's just pure happiness over there and everything. Dawn, you weren't there. I meant between your parrots and the kids, there's no way I'm staying here. Dave, I'm not staying at your house with the animals and the dogs. And it's just your dog's great, but he can't hear. And so it's just very confusing. I picked Corey because he has adult children and he lives in Florida and he lives near my son. And I figured Corey would be the best bet. So that's why I picked you, Corey.
Sounds more like I was the last option.
Well, all right. Next, Dawn.
Hi, everyone. My name is Dawn Becker-Durnan. I'm the practice leader on behalf of community associations for Acroshore. We are a fintech insurance company, and not only are we national, but we're international. And I currently serve on the South Carolina Board of Directors for CAI South Carolina, and I'm on the Blue Ribbon panel as well. And I'm also a member in several other states, particularly on the East Coast. But we are insurance specialists, including property, casualty, and benefits.
Sean, do you have a boat?
I do a boat.
Ah, see, the audience is filling me in now. They're swaying me. They're telling me Sean has a boat. You may want to stay with Sean. All right. Thanks, audience. I like all the info. You'd be surprised what I can find out about you guys from the audience. All right, Dave.
Good morning, everybody. My name is Dave Byrne. I'm an attorney and the head of my law firm's community associations practice group. We represent HOAs, condominiums, and cooperatives in New Jersey, New York, and Pennsylvania.
All right. Excellent. So I forgot to attach the panel info, but it's not a problem because I email everyone anyway, whether you were here or you missed it. So I'll make sure I include that in the follow-up email, all their contact information. And I just want to go to our mail. We always do at least one of the questions I get during the week before we get started. And the question is, can landlords sign a proxy on file for a quorum? In other words, instead of asking every year, can we just keep it for year over year? If that answer is yes, maybe we can keep it on file for other unit owners if they approve. Now, John, don't sidetrack me now on an hour-long topic on this, but what do you think about this?
In New York, proxies are good for 11 months, so you could do it if it's within 11 months, but if you're doing it for each successive annual meeting, the answer would be no.
Okay, Sean?
Yeah, the South Carolina Nonprofit Corporation Act is a slight variation of that. What it states is that if the proxy doesn't say how long it's good for, it's 11 months, but in any event, no proxy can be good for any longer than 3 years. So you could put on there that it's good for 3 years, but that would be the longest that it could be good for under state law, and then it would have to be renewed.
Corey?
In Florida, the proxy is good only for the meeting that it's noticed for, and it's also only good for 90 days in case the meeting's postponed. So it wouldn't work out in Florida.
Dave?
Yeah, I'm with the guys on this. There are limitations with respect to New Jersey and Pennsylvania about how proxies can be used, how long they're good for, whether those deadlines can be varied by proxy holder choice, those kinds of things. So you have to really dig into it before you could say whether it would work.
Yeah, so you guys don't seem that excited about this idea. So more or less makes sense. All right, here we go. Responsibilities managers and boards should not accept. And I would love to get stuff from the audience on this as we go along. But before I go any further, I'm going to launch another poll. And the question is, have you ever, how often are you requested for a task you should not be? How often? And that could be for board members or managers. How often? And a lot of people don't do the polls, which is fine. But nobody in the audience could see who said what on the poll, just so you know. So you could feel comfortable doing the poll. Theoretically I could see it, but it's not like we publicize it or anything. And I'm going to give this another 30 seconds because it's still kind of, can you guys see the status with the new system? Can you see it? Okay, yes. You can see it happening. All right, so I'm going to end the poll, but it looks like every now and then 58% said and 37% wait. I think that's a lot. 37%, now 40, more than appropriate. Anybody on the panel surprised by this? Okay, I'm not surprised by it. I actually see this happening all the time. And do you guys think it's mostly managers who are asked for things or board members? I mean, I've seen board members asked for just as many inappropriate things as I've seen managers. Greg, have you seen that?
I think it's more managers.
Yeah, but I've seen plenty of board members.
Yeah.
Okay, here we go. So the first one on the list that I have are personal errands. And I don't know if these are things that managers and board members should or should not do. And this is what our panel is going to kind of go through with today. So personal errands like picking up dry cleaning, doing any work unrelated to the HOA management. Some of these are obvious. Some of them aren't. Sometimes there's some reasoning behind it. So we're doing for both managers and boards. And Dave seems very excited already or feels like it's a really stupid question. It's either one. So we'll start with Dave.
I just can't imagine asking a property manager to go pick up my dry cleaning. I mean, it just is like something you wouldn't even if a manager said, listen, on lunch, I'm driving over to the strip mall to get a slice of pizza. Do you need anything? I can't imagine a board member would be like, oh, by the way, my dry cleaner's over there. Can you get my dry cleaning? It just seems like an odd thing to do. But a property manager in a real world situation like that could have struggles, I guess, with how they respond if they're not. There's a deft way to talk someone down from a silly request, I suppose. I don't know. I just can't imagine it ever happening, but I gather it has, or you wouldn't have asked the question.
Well, I meant, Dawn, I'll just jump to you for a second. Because actually, I realize there is an insurance aspect to this, right? And it doesn't have to be dry cleaning, Dave. It could be something that's maybe not so clear cut, right?
Well, I've thought about circumstances during disasters where people can't get to their homes and they'll ask the property manager, can you clean out my fridge? Can you, or if it's a 55 plus community and we're looking at potentially someone who's fallen and they're calling instead of an ambulance, they're asking the manager
All right,
to come in.
wait, Dawn, you're getting me. You're so
Way
far
too
ahead of
far?
me. No, go ahead with the refrigerator. The fall things is a whole other topic. So just, I never, the refrigerator thing, I don't even have on here. So please, by all means, continue, but don't encompass everything.
I think anytime too, managers asked to go inside a unit or into a home, there's so much liability and legal issues that can arise, number one. But that's definitely a personal errand that I've seen. And I've also heard of managers being asked to let dogs out. And the number 3 thing that I've heard is, can you pick my kid up from the bus stop? And this has mainly been on-site managers where parents or maybe don't have somebody else to call and they've said to the manager, go get my kid.
So like we've had requests to move furniture and change light bulbs. Other people said they've had to reprogram TV channels for people and reset routers for Wi-Fi and pick up mail. Corey, my grandmother, she didn't live in an association, but the police would come by for whatever reason. And they actually took her garbage out for her one day because she was like 90 something. So people do nice things for people all the time. How about in our industry? What do you think about managers and board members kind of blurring the line here and doing things outside their scope? Is that okay with you to use?
I think there's limitations. I think we're all human and we should be, kind to each other and help each other out. But when it starts being taken advantage of, or once in a while, hey, I'm going to pick up a salad. Do you want one? That's cool. But the dry cleaning example is a bit excessive.
Right. Let's stay away from the dry cleaning example because that's not, I was kind of going for more of a blurry area. Right. So, Greg, here at my building, the people that work at our desk, I don't like to use them as examples, but they're incredibly nice. And I see them always fixing people's phones for them. Right. And I'm just waiting for them one day to get accused of breaking a phone. What about the insurance aspects of this? Like no good deed goes unpunished. Are boards and managers going to be covered if they're doing something outside the scope? And am I using the right terminology? Scope? I'll go to Sean on that next, but go ahead.
I think you are. I like what everyone said already because there is a human nature to everything and you're trying to be helpful, but managers do need to set boundaries and there are definitely parts that are unacceptable. And yes, no good deed goes unpunished. So you enter someone's unit to go empty out their fridge and then later they complain that, hey, my $6,000 yard drill or whatever was broken and I think you did it. That's going to come back on you. In a lot of those instances, I think there would be defense on the insurance aspect. However, you're talking about an insurance claim and it's something that you want to avoid.
Sean, somebody in the audience is saying, well, how about if I do it for one person and not another? You're always talking about discrimination. Boy, that is a really good comment. I'm the manager and board members help and I do this favor. I grab the trash or something. Now that sounds like a really good example, right? Because it's stinking up the place. But then somebody says, oh, I asked you to do it. You didn't do it for me. Is that a valid discrimination?
It's not a valid discrimination claim, but many claims are not valid. It doesn't mean they don't have to be defended and that there's going to be expense and, a lot put into that. A recurring theme that we're going to refer back to today is that, what governs that relationship is the management agreement. But for one thing, there are gray areas there are things that are not, specifically delineated, that it's kind of up in the air as to whether it's something that the manager can be asked to do. And then the other thing that managers are always going to face here is, you kind of have to pick your battle or pick your hill to die on. If it's, something that's probably not within the scope of your duties per the management agreement, but it's not the end of the world and it's not going to be that big of an inconvenience to do it, they might be inclined to do it just to maintain copacetic relationships with the board,
Okay.
which, their livelihood depends on. So that's going to come up a lot.
John, I'm a manager and I just like somebody better. I'm not trying to be discriminatory, but I do. I like Mary, and I do a personal item for her, but I don't do it for Jane. Our managers are not allowed to really pick and choose in their professional capacity, but they're at the association. Can they pick and choose who they do what may be considered personal favors for if it's a personal issue?
You run the risk of being accused of treating residents disparately, and someone could use that as the basis of a lawsuit. I'm not suggesting that the lawsuit's going to win, and or anything, or what are your damages also, but we say this all the time: treat everyone the same, treat everyone uniformly, and most importantly is stick to the scope of your duties. And I agree with the comments so far. If it's a relatively mundane, simple issue, that's fine. But when you get to the dry cleaning stage, yeah, that's outside the scope.
Dave, and then we're going to go to the next one here. What if a person is a friend or relative of yours? I guess, that's a logical exception, right?
Yeah. I mean, outside the absurd examples that like we started with, life is a complicated thing. I mean, it's people, there may be situations where you do things for people, but it just really depends on the circumstances. It's not a great answer, but I don't know any other way to say it. To some things feel right, to some other people they don't.
And then Corey, actually, there is one other thing I want to end with here. Is there any difference between board members and managers? You guys keep going back to managers because that is common. But you know what? If it's election season, and you want to get elected, board members don't mind doing personal errands, but they're still on the board. Does that have any play here? Right? I'm on the board and I help you with your phone or your internet and I knock it over and I break it. I know this is an insurance thing too. We'll decide if we want to get into it, but you know where I'm going at, Corey, right? Do board members have to be concerned about it, or they have a lot more latitude?
I mean, at the end of the day, your neighbors, and coming over to someone's house is really not a function of the board or a function of the association. So obviously you can file a lawsuit for anything, but I don't think it would be a viable claim. And I kind of, getting back to what I said before, I kind of wish people would be a little bit more neighborly. And I hate to lawyer us out of being neighborly.
I think I've been lawyered out of everything now from doing so many of these. Dawn and I talk about this. We're just so Dawn helps people still, but I'm just so paranoid now about everything because I spend my entire week talking about lawsuits. Greg's laughing too because I always comment. All right. Any insurance aspects of that? I mean, basically, if you're a board member, Dawn, I don't want to dive too deep. I want to move on, but you're on a board. It's election season. You go to help somebody and you break something and break a lamp.
I think there's always concern for that. And if it occurs, it's going to depend upon, hey, I broke your vase, let me reimburse you. Or did I leave your door open and you were burglarized? And now the association may be potentially having to notify their insurance carrier of a claim.
Right. And then someone is saying, Greg, it should be neighbor to neighbor and not board to homeowner. But we're always talking at these things. You just can't say, hey, I'm not a board member right now, because you could still get the association sued.
Correct. And if it does happen and it is a neighbor and a board member, it's possible both the neighbor are going to get a lawsuit and have to report it to their homeowner's policy if it was acting neighborly, and the association's insurance is going to get involved. The burglary example was a good example. They ended up leaving the door open, so now you have a much more major claim, a lot more damage. Either one, the homeowner's policy could come in and defend that homeowner, or the association's policy could come in to defend and possibly pay on the association aspect.
So there you go. We're off to number one, and it already was like we already dove deep into it, a lot of gray areas. This is actually something a manager contacted me a long time ago because they had to direct traffic, and they thought they were going to get run over, and they told me about it, and they said I was wondering if I should have said no because I don't know anything about directing traffic, and what were my liabilities involved in this. So I'm going to launch this to the audience here. Man, I'd really like you guys to participate in this one. A board tells a manager to direct traffic in the parking deck for 10 minutes. There's an issue. I don't know what the issue is, but something came up and the traffic needs to be directed. And that happens. Is this something the manager should say no to? I don't know my answers don't matter anyway, but I can tell you right now, I don't know the right answer to this. Part of me says this is the manager's responsibility and involves the association. I don't know if you need a license to direct traffic, but then again, you've never had any training and you get run over and you're out there or you cause a crash. Where is that going to leave everybody? So you guys could see the results coming in here, correct? Okay. So I'm going to close it at the 68, 67. Most people are saying no, but a good chunk are saying yes. I definitely don't know the answers, and I'm going to start with John on this. John.
I think it depends on what the issue is. I don't think the board member has the right to instruct the manager without explaining. If it's a true emergency, right? Let's say there's a sinkhole that the cars are about to hit. If they don't get diverted in the direction they want, that makes sense. So I think it depends on what the issue is.
All right, I'll go on the hook here. I'll give you an example here. I have a parking garage where I live. There's an in and out. Sometimes maybe the gate breaks on the in. Now the out is an in also, and someone needs to sit there and direct traffic in and out, or there's going to be no parking. That's a pretty serious deal. Sean, should the manager be doing that? And of course, we're going to go to insurance too on this.
Yeah, I mean, it's almost surely not specifically itemized within the scope of duties under the agreement. It's one of those things where the manager could do it if the manager's comfortable with it, but if they're not, if they feel unsafe and upon reviewing the situation, if they just look at this and say, boy, I'm really going to run some risk here and possibly get myself into a liability situation, it would be an appropriate answer to say, listen, I can't be the one to do this. We're going to have to get a public safety officer or somebody else to do it because I'm just not comfortable with it. But depending on what it is, like you say, if it's it's probably not rocket science to, using the example you gave, to just alternate and say, okay, one car in and then now it's your turn to go out. If the manager's comfortable with that, then I don't see a problem with it.
The audience is saying, I agree 100% with John. It really depends on the situation. Other people are saying directing traffic is a specialized task. Another person is saying, I'm not qualified to do that. Once again, I'll jump over for Greg with insurance on this. Greg, I'm throwing a pretty serious one out there. I mean, are you not going to go do it? And where do all your residents go? They just have to sit there and you're the manager and you're like, oh, sorry, everybody,
Certainly an area you want to avoid. This is definitely exposing you to a lot of liability. If it's in something like John's scenario where there's a sinkhole and you're definitely saving people from impending damage, you're going to need to get out there and do it. Most of what's going to happen from this is going to be an auto accident. I know in New York State, insurance follows the car. So the person driving the car and the auto insurance for that car is primary from the insurance aspect, but you could end up getting involved in that claim if you were directing them to go where they go and something happened.
Corey, this is a tough one, I'll tell you right now, because if I came home and I couldn't park because the manager didn't want to take the liability of just kind of like directing traffic, have people take turns going up and down the same branch, man, would I be mad. But I could also definitely see one of our residents not following proper instructions and there being an accident and the manager getting blamed.
You're right. There's negligence either way. You're damned if you do or you're damned if you don't. Because if there's an accident or injury because the property manager misdirected a car, there's liability there. And if there's nobody there and there's just chaos, when the association had a duty to provide a safe environment, then you're damn there that way too. So I think there has to be good judgment based on the actual fact scenario at the time.
People are saying there's a big difference between different traffic situations. A garage is maybe a little tougher than directing traffic in another situation. Managing the HOA asset is the responsibility of the manager. Directing traffic on a street is not. I actually wasn't thinking of a street. I was thinking more of private property, but that's another interesting aspect, Dawn, and I'm going to ask you if that makes a difference. If this would be a problem for you, then park your car and direct traffic yourself. That would be in regard to having a volunteer go ahead and want to do it. Another interesting aspect. Dawn, part one of my question was, though, does it matter if it's on association property or if you're out in the street?
From an insurance aspect, most likely not. It depends upon the policy and whether there's specific location, specific endorsements that require an accident. If it didn't occur on the premises, that it's not going to be covered. The other aspect too is if it's on the street, I think it's more legal, the laws and that type of thing. But for private garages, I would make a recommendation that boards and their managers do have some protocols in place for if the garage door doesn't work, if they have to detour, having cones set up, having a way to direct that. Having a practice or something prior to an event happening can always obviously mitigate the circumstances.
Okay. And Dave, what is your final thoughts on this? And I also want to throw, how about if a owner wants to volunteer to do it? Can management look the other way? And I think I know the answer to this, and let them go ahead and do it on their own. People, this is a tough one.
Well, I mean, the manager is not going to put his or her hands on the guy and make him stop doing it. So, he does what he does, I guess. If there's a fear about it, I guess the only thing a manager could do would send some kind of email to somebody claiming I told the guy not to do it. But I think when ultimately, if a manager's in a tough spot, on a base level, they probably just ought to contact supervisors and company owners and defer the decision to someone that would be in a better position to push back if they thought there was something inappropriate, might have more knowledge of what the contract says. I mean, you probably could never go wrong if you're a manager on the front lines by saying, hey, let me just get my my supervisor on the line real quick. I'm not really sure what to do.
It's funny. You guys are leaving board members out. I could tell you right now that many owners would expect a board member to get out there and also do this job, and they would be just as aggravated if the board didn't do it. I kind of want to move on here, but does anybody want to offer any commentary? I think we already covered it, but any additional commentary? Because I will tell you right now that owners would be upset if the president did not run out there and let people park. Any commentary? Obviously, everybody, this is another gray area. You kind of, as insurance and attorneys, you're saying don't do it. But then we're also saying, hey, life is life. Dawn?
I just want to come in. I think from the legal standpoint, a lot of the attorneys always come in on these sessions. What would a reasonably prudent person do? And that's a defense for insurance as well. So obviously exercise caution.
All right. All right. So I'm not going to spend time on this one. There's a couple I'm just going to paraphrase and ask the panel if I got it right. Legal advice. Hey, if you're a manager, don't do it. Don't come close to doing it. Don't go anywhere near it, and actually don't do it for insurance. These are two things that managers get sued for all the time. It could be as innocent as saying, I'm not an attorney, but John, is that accurate? That doesn't necessarily get you out of the problem, right? I'm the manager. I'm not talking board members. We're going to do that in a second. I'm a manager, and I say, I'm not an attorney, but.
No, do what Ray Dickey does. I'm not an attorney, and he doesn't give legal advice.
If you notice during these live streams, I always go to the panel, even though I make it
right.
very clear that I don't know anything. So you are agreeing with, all right. So the panel's agreeing with me. Don't come anywhere near it. Okay. Let's talk about board members. They're not they're volunteers, right? And I'm just sitting around the board meeting. I'm Joe, the board member. And I said, you know what? I think legally we're not supposed to do this. Sean, I have a funny feeling that may be okay or no?
It's just not advisable to avoid talking to the attorney about it. It comes up a lot because a lot of boards with tight budgets are sometimes inclined to avoid talking to the attorney to try to save that cost. But we always say you're going to end up paying more in the long run by making that decision. So it's just not advisable, not prudent, not a good idea.
Okay. Corey, you agree? Just don't do it. Don't go anywhere near it, whether you're a board member or manager.
I would just follow up the sentence with, this sounds like it might not be legal. Let's call our attorney and find out.
Right. And then Dave, how about if do you agree with reinforcing the idea that the law is complicated and there's a good chance you're going to be wrong? I sit here all the time and make a story or a comment and you guys say I was wrong. So that's another reason to go to legal counsel. Do you agree?
It is, and in some ways, the most fundamental reason to go to legal counsel is just to move your liability onto a third party. If you are wrong, you can blame somebody else at the most base level of human interaction. If you get someone to give you advice whose duty it is to give you that advice, and they give you bad advice and something happens, you have someone to point the finger at. And that sounds childish, but that's what you do when you hire professional people. It's what you do when you hire anybody to do anything. I mean, you could try to fix your own car, but you go to a mechanic because it's more, if he does it incorrectly, you probably will be able to get your money back or get a new car. I mean, that's just what people do. And lawyer is no different.
Okay.
If you're confused, you call your lawyer. For the very least, you move your liability to whomever you've called.
Greg, I want to kind of move along here as quick as we can, but what about the insurance aspects of this? You give the advice and you're the manager and you get sued, and then do very quickly. Well, we'll save the board version for Dawn. How about the manager version?
Yeah, the manager version or the board version, they don't want to give, they don't
Right.
want to be giving out professional
But are
advice.
they covered?
At the same time, your managers know a lot. They're going to discuss a lot, but what you have to do is what Dave just said. You have to back it up with the professional and whatever it is you're getting the information from, and have it so you can point the finger elsewhere.
Are they covered?
Oh, are they covered?
Yeah.
No. I mean, they're not going to be covered for acting as a lawyer. There very well could be defense for the association, because basically in general, it's going to come back just that they made this mistake. So it's going to be a discrimination claim. It's going to be whatever type of claim. So there could be coverage, but you do not want to be acting as a lawyer or an insurance agent. There's definitely some holes.
Wow.
Depending on what happened.
So maybe no coverage for defense if you really screw up. Okay.
Mhm.
Yeah.
Dawn, I'll assume you agree with Greg
Yeah.
on that. If you don't, but hold on.
Mhm.
If you could do the board member part, I would
Yeah.
appreciate it.
We often have attorneys, insurance agents, professional engineers that serve on a board. You are acting outside of your scope of authority. When you're giving professional advice to a board, you're violating a lot of ethics, of course, but most importantly, that if it's biased typically as well, but you're not protected by the DNO. In addition to that, if you're still actively working as an attorney or an insurance broker or an engineer, your company may not want you to do pro bono work, and they may not cover you as well under their professional liability. So I would not do it. Defer to the professionals all the time.
All right. Financial decisions. This one's just for managers. Making financial decisions without board approval, as such as large expenditures, investing HO funds. Look, I don't think we need to spend a lot of time on this. This would be within your scope, right, of your contract for the most part. Maybe you can go ahead and buy some water for the gym, but you certainly can't go and get a paving project done. Dave, am I right here? Where do managers know the line here?
I mean, how do they know when to seek advice?
No, right. I'm a manager and I'm comfortable ordering some, well, even in my case too, right? Like as well, I don't want to use myself as a case, but I'm the manager and I'm okay ordering some coffee cups and some coffee, but I certainly don't want to have a paving project approved and spend the money. Where's the line?
Well, that's a good question. I guess there's multiple levels. Like the first question would be whether or not the manager has certain authority to do certain things to begin with. But the second question would be, again, I mean, I hate to fall back on this, but maybe it's just the way I think. I don't know. But if the decision's big enough where the consequences of failure will be big and politically problematic and dramatic, that's probably the time to get someone else sort of in the room to be able to minimize your personal exposure if something
Okay.
doesn't go wrong. But buying coffee cups, if you buy the wrong kind, the likelihood is there's no consequence to it. So there's no point in calling anybody, but it
Okay.
changes when the dynamic's different.
Corey, I think the audience figure just went out because I got like 4 of these. Your contract should have a dollar limit on the amount that you can approve. Is
Yeah,
that,
we see
I
that
meant,
there.
is that sounds like a simple solution. Am I wrong?
Most of the management contracts that we review do have dollar limits, usually under $2,500, with exceptions if there's an emergency or something like that. And if there is an emergency, there's a procedure for also getting approval from the board. But if I'm a manager, I mean, I'm in the manager's shoes, I don't think I would want to really spend anything without getting approval from the board just to cover my own butt.
Yeah, I don't know. Like, is it all right, Corey, if I say that's going to get kind of ridiculous, though, if you're running a large association? I mean, you can't check with them on every expenditure. I meant,
Obviously, office supplies, stamps, stuff
Yeah,
that's
but
needed. But if there's anything that has some level of discretion, I wouldn't want that liability.
anything outside the norm. Is that okay?
Mhm.
Okay.
Yep.
John, can we leave it there?
Yeah, just check your
Okay.
management agreement.
Okay. Greg, insurance issues with this? Okay. Dawn, no insurance issues. And thanks, audience. That's a great one. Go ahead, Dawn.
Checks and balances, as the attorneys have talked about, that is essential, especially when we're providing fidelity insurance on behalf of our community associations.
During emergency, our manager could spend up to $2,000 and get board approval. Yeah, I guess it would be good to have a different dollar amount for certain kinds of emergencies. That sounds like a great suggestion. A lot of people saying that is a similar scenario. I don't want to bounce back, but people are really confused about this thing, in my opinion. People really, I really want to move on, but I'll jump into it for a second. Let's backtrack. So the financial decision thing, we're done. Maybe get a dollar amount, I think, for the most part, our panel saying, and get your guidelines and off you go. Is everybody okay with that? All right. Let's just go back to this, in my opinion. People think that you could just say, in my opinion, and it's clear. In my opinion, Bob is a child molester. In my opinion, I meant really quick, John, is it, in my opinion, everybody is entitled to their own opinion.
So you're talking about libel, and it does kind of, it helps, right? If you say it's your opinion, you're entitled to your opinion, however ridiculous it is. There are limits. You still can't discriminate. You still can, if it's considered reckless the way you say it, you could still expose yourself to a libel claim.
Okay, so can we leave it like, in my opinion, could be helpful in some cases, but it's not a protective shield under all scenarios.
But I would actually advocate for it. I think it really would help.
Anyone else on the panel have any issues or additional commentary?
I would just say,
let's go. Wait, hold on. Let's go to Sean, and then we'll go to Dave. Go ahead, Sean.
I would just say if that's being used as an attempted qualifier to get around the obligation of consulting with the appropriate professional, whether it's a legal, financial, insurance professional, and saying, well, in my opinion, we should do this. Right. If that ends up being heated and the prudent, necessary thing to do is consult with a professional, then that qualifier is not going to protect the association from making that decision without the appropriate consultation.
Well, you're right. So if the intent is not to spend money and get a professional thing, it's not going to be the same as if you just said, in my opinion, gave your opinion. If you disagree, let me know. Dave.
Yeah, I was just going to say, I think John's exactly right. But I think I guess he's exactly right. There's no but to it, but I was going to add to it, which is that it depends on like the thing. Like, in my opinion, he's a child molester. I think that clearly would help you. But in my opinion, I saw a guy leaving the building this morning at 8 a.m. with a 3-year-old child, and it wasn't his own. Like, in my opinion, that would be more problematic because you're actually like laying out specific facts that you observed as opposed to conclusions you've reached. When you throw on, in my opinion, at the end of both, I think it would be totally different. But yeah, if you're going to tell someone, I think that guy's a child molester, I think he's a crook, in my opinion, that would probably keep you clean completely.
Right. But if you said, in my opinion, Joe is really behind in his dues.
Well, in my opinion, I saw the guy actually take money out of the
Yeah,
cash
all right.
drawer and put it in his pocket, in my opinion.
All right.
Probably wouldn't work.
I'm going to move quick on some of these board decisions. If you're the manager, make sure you know what decisions you should be making and which ones you should not, and make sure that your board has proper policies in place so you could fall back on them. Anybody have any issues with my statement? Okay.
No.
Voting, participating in board votes or influence other board decisions beyond providing professional advice or information for managers. I feel like we're going to end up spending a half hour on this one. I mean, I don't understand this one. Isn't this what managers are supposed to do, Corey? Offer information to the board to help them to decide how to make their decisions?
Yeah, they're supposed to share their experiences in managing, and then the board takes those experiences and makes a decision.
So why don't we leave this one, John, then once the manager gives their information and their opinion, then they should stay out of the process and don't get involved with the politics. Are you comfortable with that being the proper way to look at this? Okay.
Yes.
Interesting. All right. Anybody else? Sean, Dave? Okay.
No.
So far, no insurance aspects. Personal use of HOA resources. They're talking about funds for the unrelated to the HOA. Managers and board members, this is just a no, right? Can we just leave it at that? You're not supposed to do it. Okay. Any comments? Greg, did you have something else on it?
No, that's just a
Okay.
huge problem. You can't use HOA funds for personal resources, period.
Confidential information, sharing confidential information could get you in trouble. They mention my research for personal gain. Okay, so we know, Corey, that board members and managers are not supposed to give out confidential information, but why does the aspect of personal gain come here? If it's not for personal gain, are you going to get in less trouble?
No, I mean, there's consequences, it's confidential for a reason. And it's depending upon what that information is, there are certain consequences, if it's released, for whatever reason. If it's a attorney-client privilege or work product for litigation that gets out and destroys the case, there could be consequences for the association.
Okay.
If it's personal information on a fair housing reasonable accommodation, like a medical record or something like that, there could be consequences across the board.
All right. Any additional commentary on this? All right. So this is a good poll question. It's timely because we just kind of touched upon it. I'm going to launch it. A board and manager go out to lunch to discuss HOA business. Can they charge it to the HOA card? The board member and manager go out to lunch and they talk about the HOA. Can they have their association pay for their lunch? Is this something that managers should or should not get involved in, and board members? I could see the manager actually having the card. I don't want to get into a whole side topic on who should have cards and who should not. Looks like 71%, but it's dropping. It's floating, are saying no, don't do it. I'm going to end this poll here. Let's start with John on this. John?
There could be reasons why you could do it, but my answer is don't do it. It just looks bad. What's there at lunch that you couldn't do during working hours? Why do you have to incur the expense for lunch?
Okay. Sean, isn't there some kind of aspect, maybe it's more accounting, where if you have to have lunch anyway, you can't deduct it or some kind of thing like that? You know what I mean? Like you got to eat anyway. So why should you charge the association for it?
Yeah, and I mean, I think John articulated it well. This is that same discussion could be had over the phone or in a meeting in somewhere else where you wouldn't have to pay for a meal. So it's one of those things where it could possibly be justified, but it's just why do you want to go there? It probably didn't cost that much. So the best policy on this is that the the manager and the board president should just both pay for their own and, just not do that, not invite the trouble that it could
All right.
potentially cause.
A lot of the managers don't agree. They're like, listen, if the board member is asking me to go out to lunch to talk about HOA business, why should I have to pay for my own lunch? Other people are saying, what does this mean? For me declining to go to lunch, like there's a lot of comments here, Corey, where the manager's saying, this is the manager, not the board member. Board member says, hey, let's go have lunch. I want to talk about HOA business. I kind of agree with the comments I'm seeing. Why should the manager have to pay for lunch? Maybe they didn't have the money. Maybe they never go out on lunch on their own. Corey.
I've never seen an HOA or condo budget that has a line item for lunches. It's not a profit, or it's not a for-profit organization. There's no entertainment, line item to bring in new customers to develop business. You're dealing with your neighbor's money. And I'm sure if you polled the neighborhood, the neighbors would not be happy that the money was being spent on lunches without being invited, the whole community being invited.
Man, Dave, I'm going to throw two things at you here. Okay. First of all, like I see the manager's point here, right? Maybe they didn't even want to go out for lunch and the board member's dragging them out to lunch and they're talking about board business and the manager's answering. I don't see why the manager should have to take money out of their own pocket to pay for it. The other question I'm getting, if we could put it together, because we're going to run out of time here. What about if an entire board has a meeting at an expensive steakhouse? Can they put that on the association card? Now, I don't want to get sidetracked on a whole ethics topic here, but what can you do with those two questions?
Yeah, I think that the words red flag are invented for this kind of thing. I think that the manager who doesn't want to go to lunch, who can't afford it, which is certainly a real world possibility, the person should go and then expect his or her boss management company to pay for it. And then that person, then the boss has to then go to the board member saying, listen, that's just not going to work for us. I do think that I've had this happen, not often, but it's happened. I think you could easily float the idea that when you have a board meeting at a physical location, and you order up pizzas and that kind of stuff to come while the board's meeting at an actual meeting, I think that's floatable. I think that passes the smell test. Going out to an expensive dinner, that's like the kind of stuff like a fraternity alumni board does when they're, with the fraternity dues. It's just like it's like an unnecessary, excess.
But that's an ethical aspect, right, Dave? Because theoretically they could do it. Well, it'll be up to the owners. It'll be up to the owners for the repercussions.
They could take the money
winning.
and burn it in the parking lot. I mean, they have a fiduciary duty at the baseline of things, they have a fiduciary duty not to do stupid stuff, and it just,
all right.
It just doesn't
wow,
work.
this is like a whole other topic here, audience. I'm going to do this as a topic because I'm getting a lot of questions here. We have a line item for board and staff appreciation. I guess that's a line item for money. I don't know if you guys have ever seen that.
Board and staff appreciation. Is that board appreciation? Like actually, like
it says a line item for board and staff appreciation. I can see it for staff. I'm surprised by board. If a manager is doing this, the management company should pay for this. Dave, I think you said a lot of people jumped all over that and agreed. Can the association pay for funeral flowers for a board member? Sean, if you can't do it quick, let's not do it because we're going to run out of time.
I mean, it's probably not something that ought to be done, but is it going to be the end of the world? Probably not going to cost that much, and it's a nice gesture. Right. So it's a gray area.
Dawn, if the manager and board member go out for lunch and the manager chokes, can the manager's family sue the board since it was association business? I guess they're asking for coverage. Is there coverage?
It depends. There's the Good Samaritan part to the insurance policies that is often built in if you're helping someone and really under the guise of that. But that's a loaded question there, Ray. I mean, you always ask the ones that could be anything.
I know. That's why I like those.
What would the board member be sued for? I mean, he didn't do anything. He just.
I don't know, Dave.
Well, Dave, a suit sometimes. Somebody sues because they didn't act, right?
Then I get dismissed. I mean, if the question is, can I be sued? The answer is always yes,
We
because
know
any
that, but
idiot
I
can
meant,
file a complaint. But
I
the
asked if
answer is,
there
can
was,
the lawsuit survive any test of credibility? Then I can't imagine, unless the board member poisoned the guy. I mean, I don't know why
Dave,
going out to lunch is going to work.
that's not what I asked though. I asked if there was coverage. I asked if
Oh,
there was coverage
coverage. Oh,
because we
for
already
what
know
though?
that. All right,
Oh.
Greg, any commentary on whether or not there'd be coverage?
I think there'd be defense on that part of the
Okay.
claim. But for the rest of it, I just wanted to comment, it's really the cumulative of how all of this looks down the road, because we do see several crime claims. And when they go back and it's a new board questioning the property manager, a new board questioning the old board, and they see all these expenses, and then you're accused of stealing from the association, how does it all look and how does it all add up to?
Okay. Maintenance work. I'm just going to leave this one. Don't do it. If you're the manager of the board, don't have anybody else do it. Somebody falls, somebody's get hurt. So that's going to be a problem. Just don't do it. Any problem with this panel? Okay.
Yep.
Dispute resolution. There should be, I guess you have to follow whatever your state laws are in some issues in regard to this. You should use a mediator. You don't want to overstep. Here they're saying a manager should not get involved in dispute resolution. That's another gray area one, John, right? Because what does that mean? I got a problem with Joe and the manager just can't try to figure it out. I mean, we're not talking about here.
Yeah, I mean, there are plenty of examples we could think of that you want the manager to like help work things out. Neighbor to neighbor disputes, boards don't really have to get involved, but if they escalate, it just detracts from everyone's peaceful possession. So, yeah, I think there are a lot of ordinary ones that mediation, not formal mediation, but just, try to get
All right.
people to get along.
Where's the line, Sean?
I
Where's
think
the
it's
line?
the last thing that John said there. There's a distinction between formal procedural dispute resolution with regard to a filed lawsuit or a filed claim, as opposed to two neighbors that are arguing about something and the manager taking on the role of finding out what's going on and then reporting back to the board and making a recommendation of how it can be resolved through some directive given to these folks about who's right, who's wrong, what they both need to do to work it out. But that would be on the informal side.
Any more commentary on this? And I feel like the last few sessions have all been gray areas, which is which is interesting. Just, I guess what you guys are saying, if this one has the possibility to be possible litigation, stand clear of it and take a different approach. Sean, is that okay?
Right. If it's a lawsuit, you got to get an arbitrator or a mediator, not the manager.
But if it has the potential to be a lawsuit and someone says, I'm going to sue, then you got to step aside. Yes?
I agree.
Okay.
Yep.
Thanks. Accepting subpoenas. I don't know why this was in here. Corey, any reason why this is in here for a manager not to accept subpoenas? I mean, maybe they accept it accidentally. I don't know.
The better practice is to, at least in Florida, we recommend that our clients name the attorneys as the registered agent for any service of process or subpoenas. And the reason being is because there's a strict time limit for a response. So some of our clients do have their management companies or the managers accept service of process. It gets put on a table, and then 20 days goes by and there's a default. So I would prefer, we generally recommend that the attorney for the association is the one who accepts service and subpoenas.
I'm going to do this as another topic, audience, because I have a funny feeling if I go to lawyer to lawyer to lawyer, I'm going to possibly get different aspects of this based on a lot of different circumstances. Does everyone on the panel agree that this is maybe we need to spend a little bit of time on this one? So I'm going to kind of go over it and move on to the next one. You know what? I just want to get this out here because I found this interesting. I'm not going to do it as a poll because we don't have time. You know what? I'll do it as a poll because I just thought this was really interesting, and then we can share about it. Someone on our panel actually testified before the U.S. House of Representatives, and I want the audience to take a wild guess on who it was. Someone on the panel, because I had this on my sessions for the last 4 sessions and I've never gotten to it, and I don't know how you would know or not know, but I'm just kind of curious to see where it comes. And I'm going to close this poll awfully fast. And like this was, you can see Adam's on here and he's not even here. And I'm going to end the poll. And mostly everybody said Dawn, but it really doesn't matter. It's pretty much easy. Corey, it was you, correct?
Yeah, I testified before the House Ways and Means subcommittee on Social Security. Actually, when I was a senior in college, testifying regarding identity theft and student ID numbers.
So we'll go back to that because I'd like to just hear about that because it sounds interesting. Anybody else testifying? I don't know. Okay.
I testified at a state New Jersey Assembly Senate hearing 20 plus years ago about a law that association related law that they were thinking about passing, which I
thought it was interesting. So sorry, Corey, it's been on there for like the last 4 or 5. I never got to it. Okay, I'm gonna move quickly here. So babysitting. Oh my gosh, like we all know. We don't even have to discuss it. Don't do babysitting. Pet sitting. It's almost like the same thing. Plus,
definitely do that.
And you could get bit by the dog. You could get hurt, or the dog could get hurt, or end up dying. Spying on neighbors. This is, we have to do a whole other topic on this. We do them as other topics, but for the most part, you're not supposed to spy on the neighbor. But then again, as a manager, sometimes you do have a right to investigate or see things. I don't know. Dave, can you sum this up in 30 seconds, or do we have to do a pass on it?
I can say within 30 seconds. It depends on what you mean by spying. I mean,
right. Okay. Leave it at that. All right. Yeah, that's what I was getting at. So that's another gray area. Dog poop patrol, whether or not you have to pick up dog poop, it could be considered a hazardous material. I would say no, that's maintenance needs to do that. Anybody disagree? You don't control the weather. I know that I put that in there. It's kind of silly because everyone likes to complain to the manager about everything. Soliciting discount coupons for businesses. We're going to have to circle back on this one, audience. All right, let's do it. I got to do it, okay? Because this comes up all the time. You're the manager and the board says, hey, we want you to go around and get discounts at the local pizza places. Dave, I'm going to go right around really quick. Manager's job? It's for the association.
It's definitely not his or her job.
Okay, Corey.
This is the first time I've ever heard anything like that.
Oh, it's a thing. It's going on. Sean, it's on company time.
Yeah, but it's not one of the duties that's in the management agreement, almost certainly. And so right. I think the move would be to have the management company supervisor contact the board and say, yeah, we can't.
All right, John.
I agree with Sean.
All right. You shouldn't have to pick up dead animals. That is actually something that came up at what session? Anybody in the panel disagree? Just yell out. Vermin control. You got professionals for that. These are all things that managers have gotten in touch with me. They've been asked to do. Biohazard cleanups. You could say no. You don't have to do that one either. Cleaning up decomposing food. That's kind of another, I don't know. Geez, we only got like 3 minutes. Corey. There's a bunch of food left out, and does the manager have to throw it away, or can it just sit there and reek and cause a health hazard? Is this going to be like back to the traffic one?
Yeah, I mean, is there a janitorial staff that would come after a special event? Someone's got to do it.
Oh, I've had police ask me to keep an eye on people that they were going to try and arrest. Boy, we're doing that as another topic because I don't really know if the manager should do that and get involved in that. Where do some of these managers manage? They are real things. All right, let's do closing thoughts really quick. A lot of great stuff for some future topics. That's why in a month or so, we're going to go a little longer for people. All right, let's go. John.
Don't do it.
No, I mean closing thoughts for the whole program. Don't do it.
Don't listen. Defer to your professionals. Don't try to stay within your scope.
Okay. Sean.
Yeah, it's very beneficial for both the manager and the board to be closely familiar with the management agreement, what it says and what's in there. And if there are any provisions in it that they don't understand, they think are ambiguous, then that's something to bring up with legal counsel to make sure that those roles and duties are completely understood.
Greg, 10 seconds. Your 10 seconds is over because you're muted.
Sorry. How would an objective third party look at what you're being asked to do in the future? Think about that. And if you think it passes the smell test, I think as Dave said earlier, maybe it's okay, or maybe it isn't.
That's a good one. Wow, Greg, I'm glad we waited. Dawn.
I think ultimately, I love what Greg just said. I think
Yeah.
that's important, but also make sure it's a diverse group, not just who you surround yourself by. Don't act outside your authority or your scope of authority. You're not going to be protected under your D&O. You may not even be defended under your general
Okay.
liability. So just really adhere to that contract. And if you have questions, ask.
Dave, really quick.
God gave us instinct, so I think you should use it. People should use it mostly.
I like that one. That's a good topic, Dave. You and Greg on fire.
No,
Corey,
whether God
wrap up-
exists or whether you get instinct from God.
All right, you go too far as always. Corey, take us out of this session.
I'll go with what Dave said and wish everyone a great holiday weekend.
Yeah, everybody have a good time, and I'll backtrack on some of these for future topics. And panel, thanks for letting me rush you. I appreciate it. And audience,
Thank you.
great job today. You guys definitely helped out with the program. Thanks, everybody. Thanks for being here. Bye.
Bye-bye.
Bye.